Well, good afternoon, everybody, and welcome to Case Western Reserve University School of Law for those of you who are not students here. I see many familiar faces for people who have come to other of our conferences and programs. I see many students here, and I see many new faces, and it's very exciting for us. This is the annual Klatsky Lecture, and let me begin by telling you about who Mr. Klatsky is, who was generous enough to endow this particular lecture. This was endowed in the year 2000, so this is the 6th time we've had a Klatsky lecture. Our former Klatsky lecturers have been such prestigious people as last year's David Crane, the Chief Prosecutor of the Special Court for Sierra Leone. We had Abby Sachs, who was a judge, or is a judge, from the High Court of South Africa. We had Richard Goldstone, who was the prosecutor of the Yugoslavia Tribunal and Rwanda Tribunal. And now we are going to be hearing from Eli Rosenbaum. And before I tell you about Eli, let me tell you a little bit about Mr. Klatsky. Bruce Klatsky is chairman of Phillips Van Heusen Corporation and a trustee of this university who's also on the board of directors of Human Rights Watch. And he thought that it would be wonderful if we had a very prestigious lecture every year in human rights law, and he also gave us money to fund internships at Human Rights Watch for some of our students every year. Now, this year's Klatsky lecturer is none other than Eli Rosenbaum. I met Eli about 14 years ago at a conference and have always been very impressed with him. The first day that I moved back to Cleveland to take this job at Case about 4 years ago, there was a Plain Dealer Sunday magazine article about Eli Rosenbaum. And the first thing I thought was that that was some kind of an omen, and as soon as I can, we're going to have him out here to give a speech. Well, in his 20 years as a member of the Office of Special Investigations at the Department of Justice and now as director, he and his colleagues have tracked down and taken action to deport or extradite some 61 Nazi and Japanese war criminals who have illegally entered the United States and been living undercover. 12 cases are currently being litigated. Dozens more are under investigation. Now, just last year, the U.S. Congress significantly expanded the jurisdiction of this very unusual and important part of the Justice Department and gave it jurisdiction not just over Nazi war criminals, people who are now in their 70s and 80s, but also over war criminals from the former Yugoslavia, from Rwanda, from Sierra Leone, from Cambodia, and from Iraq. So suddenly his office is extremely busy. They're having a growth in hiring, and everybody is working overtime. ABC News recently called Eli Rosenbaum's office the most successful Nazi hunting unit in the world. And Eli and OSI were awarded the Anti-Defamation League's first International Human Rights Award in 1997. Now, I should mention to you before I bring up Eli that he is also the author of a wonderful book called Betrayal. It is about the Kurt Waldheim controversy, and if you don't have a chance, you should get it from the library or from Amazon.com, because I think you'll find it a wonderful read. Also, after you leave this event today, there's going to be about a half hour of a reception upstairs, and then on your way home, you could turn on WCPN, and at 7 o'clock, you can hear the broadcast of our mock congressional hearing of the NSA wiretap controversy, which was held here a couple of weeks ago. We have a couple of other interesting and unusual events coming up, which we hope you will attend, including Colonel Morris Davis, who will be here on March 7th, which is a Tuesday, to talk about prosecuting Al-Qaeda before the Special Military Commissions. It's his first ever public speech. And he's chosen this law school because we've been doing work for 5 international tribunals and also for his office. And interestingly enough, we're hoping to be doing work for Eli Rosenbaum's office in the future. And then on March 31st, we're having a huge, very unusual conference called The Fifth Plague. It's a counterterrorism simulation where we have experts at the local, federal, and international level role-playing themselves as an international terrorist conflict unfolds. So lots to look forward to, but right now we've got something really special, and that's Eli Rosenbaum. And it is my great pleasure to present you this on behalf of the Dean and my colleagues on the faculty and the students, and thank you again for coming today.
Thanks so much. Thank you. Thanks so much, Michael. Good afternoon, everyone. I'm very grateful to the Frederick K. Cox International Law Center, and especially to its esteemed director, Professor Michael Scharf, for the kind invitation to appear before you today. I was very fortunate to meet Michael, as he mentioned this story, when he was a State Department official. Since leaving government service more than a decade ago, he's continued indefatigably to apply his extraordinary talents to the cause of justice, particularly on behalf of the victims of genocide, war crimes, and crimes against humanity. I was very pleased to see that the remarkable work that he and his dedicated cadre of law student volunteers have done and continue to do in support of war crimes prosecution efforts around the world earned a Nobel Peace Prize nomination last year. Wow. It's quite fitting, actually, that Case Law School has emerged through the efforts of Michael Scharf, Paul Williams, and others as the leading center in the academic world for the provision of legal research and other practical support to war crimes prosecutors. After all, Case has long been the law school home of a hero of mine, Professor Henry King, who as a Nuremberg prosecutor was a pioneering war crimes prosecutor and who for 6 decades now has been one of the great champions of using international criminal and humanitarian law to vindicate the rights of persecuted peoples. Upon their liberation, survivors of the Holocaust swore never to forget what had been done by the Nazis to millions of innocent people, and they pledged to do what they could to ensure that the world always remembered. Henry King's life's work has fused that memory to action, harnessing it for the betterment of our increasingly imperiled world. It is always a thrill to be in the presence of Professor King, and it was a privilege and a joy to be able to spend some time with him on the law school campus earlier today. I'm delighted that we are joined here as well by 2 gifted Justice Department colleagues of mine, whom I will now embarrass, from the Office of the United States Attorney for the Northern District of Ohio, who've played major roles in OSI's efforts to secure a measure of justice on behalf of the victims of Nazi crimes against humanity. Assistant U.S. Attorneys Extraordinaire, I think that's in your title now, Michelle Heyer, a former OSI senior trial attorney, and Michael Ann Johnson. OSI and the cause of justice has benefited enormously from your brilliance and from your unswerving dedication to mission. Can you stand? And so let everyone see you. Both of these great pursuers of justice and outstanding public service are, by the way, alumni of this great law school. And Ms. Johnson teaches a course here, I didn't realize that until a few minutes ago, in trial advocacy. Bravo. Are there any survivors here? Well, there might be. I should mention in any event that the Holocaust survivors are the true heroes of our office's prosecutions of Nazi criminals. Time and again, they've been willing in American courtrooms to reopen and relive in those courtrooms, I should say, the nightmarish encounters with evil that they somehow endured over half a century ago. In doing so, these survivors have voluntarily and with enormous courage reopened deep and terrible psychic wounds that have never healed, that can never heal. In more than 20 years of investigating and prosecuting Nazi criminals, it has surely been the single greatest privilege of my professional career to meet so many survivors and to have been entrusted with the precious gift of their memories. This year marks the 60th anniversary of the Nuremberg trials, at which many of the most heavily implicated Nazi criminals were brought to justice by Henry King and his colleagues on behalf of the victorious Allied powers. Those trials were landmarks in the history of jurisprudence. The trials also accomplished an unprecedented documenting of crimes against humanity through the testimony of victims and perpetrators, and especially through the contents of thousands of incriminating Nazi documents captured by Allied forces. The horrors perpetrated by Adolf Hitler and his acolytes were established beyond doubt. Those who conceived, prosecuted, and judged the Nuremberg trials hoped that its legacy would include follow-on trials that would be held whenever and wherever war crimes and crimes against humanity were systematically perpetrated. Tragically, that did not happen. The Cold War, which began even before the hot war between Allied and Axis forces ended, intervened. East and West sought to rebuild the European territories in their post-war spheres of influence and turn them into reliable allies in the Cold War. Within 3 years of the end of the war, the Allies largely gave up on apprehending and prosecuting Nazi and Japanese war criminals. Moreover, some of the worst offenders were set free, their sentences reduced dramatically, commuted entirely. In a formally classified 1948 British Foreign Office cable, the Foreign Office advised all of the corresponding offices in the Commonwealth countries that by the end of the year, the United Kingdom planned to discontinue pursuing these war crimes cases. In the cable, the Foreign Office went on to urge the other Commonwealth governments to do likewise. Those governments quickly brought their war crimes prosecutions to an end. There was, you see, another battle to fight, the Cold War with the Soviet Union, and West Germany was needed now by our side as an ally. Thus, the deterrent effect that the post-war threat of prosecution for war crimes and crimes against humanity could have had, and perhaps did have very briefly, soon was squandered. The results that the world experienced over the ensuing 60 years, in part because of this absence of a credible and consistent commitment by the major powers to bring war criminals to justice, are almost too painful to contemplate. The 20th century eventually came to be termed by historians the age of atrocity, and by legal scholars the age of impunity. And it certainly isn't hard to see why, is it? Between 1900 and 1987 alone, it's estimated that governments and government-like organizations murdered fully 169 million civilians. Meanwhile, fewer than 1% of the perpetrators have ever been brought to trial. Those deeply shocking statistics, along with the fact that mass murder continues to be perpetrated in the 21st century in Sudan and elsewhere, speak volumes about the urgent need for systematic and aggressive law enforcement action to apprehend and bring to justice the perpetrators of genocide, war crimes, and crimes against humanity. The end of the Cold War in the 1990s appears to have been a necessary condition for awakening in many governments what might be termed the Nuremberg spirit. Striking evidence of this change may be seen in the fact that 2 years ago, Interpol conducted its first ever international expert meeting on war crimes, genocide, and crimes against humanity, at which I was actually among the presenters. Last year, we met again. Is it not tragic, however, that it took well over half a century after Nuremberg for the world's law enforcement professionals to realize at last the need for such a meeting at the organization that is central to the exchange for law enforcement information among governments? I should note that the multiple ironies of our meeting at the Interpol Secretariat General Headquarters in Lyon, France, were not lost on me. During World War II, Interpol had been headed by two infamous Nazi criminals, first Reinhard Heydrich, and then, after his assassination, by Ernst Kaltenbrunner. It was, moreover, in Lyon that the notorious Gestapo killer Klaus Barbie perpetrated some of his worst excesses. And then, after the Second World War, Interpol adamantly refused, well into the 1980s, to assist my office and other law enforcement authorities in investigations of Nazi crimes, a refusal that was predicated on the specious claim that these were, quote-unquote, political offenses in which Interpol's charter forbade involvement by Interpol. Well, we now see national governments at last taking action to bring human rights abusers to the bar of justice in their domestic legal systems. This is happening, moreover, not only in countries such as Rwanda and Cambodia, in which human rights violations occurred, but also in countries to which perpetrators have fled, particularly in Europe. It's also happening in the United States, as I will detail shortly. At the Office of Special Investigations, which not long ago marked its 25th anniversary, or I should say the 25th anniversary of its creation within the Justice Department's Criminal Division back in 1979, my colleagues and I have been pursuing and, I believe, securing juridical justice in cases of egregious human rights violations, specifically Nazi and Imperial Japanese crimes of persecution throughout the quarter century of our existence. In the absence of extraterritorial statutory authority to institute criminal prosecutions in these cases, we've brought civil citizenship revocation actions, so-called denaturalization cases, against participants in Nazi crimes. These cases are brought in federal district courts based on proof of illegal or fraudulent procurement of citizenship, and they are followed, when we prevail, by deportation, or as it's now called, removal actions that we bring in U.S. immigration courts. All of the cases are heard by judges without juries. Our burden of proof is far higher than the one that applies in most civil cases. We must prove our cases by clear, unequivocal, and convincing proof, quote, that does not leave the issue in doubt. In denaturalization cases, the Supreme Court has ruled that this is, quote unquote, substantially identical to the criminal laws beyond a reasonable doubt standard. For obvious reasons, at this late date in our World War II work, OSI must race the clock like other prosecutors in the country can scarcely imagine. Alas, the Grim Reaper sometimes wins, and that's become what one might call an occupational hazard of our work. The goal throughout OSI's history has been to remove the defendants, either through deportation or extradition, preferably to countries that do possess criminal jurisdiction, a goal that we've accomplished many dozens of times. To update the statistics that you heard before, during the past quarter century, OSI has won cases against 101 participants in Nazi crimes against humanity, a total that exceeds the number of such cases won during that period by all of the other governments of the world combined. That record has earned the United States the distinction of receiving the A rating of the Simon Wiesenthal Center in all of its annual reports on worldwide law enforcement activities in Nazi cases. Indeed, the United States is the only government in the world ever to have received that coveted rating. When OSI was established by Attorney General order in 1979, there was an enormous initial skepticism, both within and without the federal government, that it was possible to prove these complex cases decades after the events in question in U.S. courts located thousands of miles from the scenes of the crimes. These are the ultimate cold cases, if you will. OSI's work was further complicated by the fact that the crimes were committed in a manner intended to physically eliminate those people who, had they survived, might have been able and willing to identify the perpetrators. Also, German forces burned large numbers of incriminating documents when they realized that they were going to lose the war. We knew as well that we would not have available to us, except in exceedingly rare circumstances, the kinds of evidence that prosecutors the world over are accustomed to being able to present in court. Murder weapons, fingerprints, DNA evidence today, and as I mentioned, eyewitnesses. We knew that we wouldn't even have the corpus delicti. Despite these daunting obstacles, the dedicated attorneys, historians, and support personnel with whom I am privileged to be associated at OSI and in U.S. attorneys' offices around the country continue to investigate and prosecute the cases successfully. We have, in fact, prevailed in the vast majority of our prosecutions. Today, we still have nearly 20 cases against alleged Nazi criminals pending in federal courts around the United States, and some 50 World War II suspects remain under investigation. OSI and its work, we believe, are manifestly part of the legacy of Nuremberg. We've built and won our cases largely on the basis of incriminating documents and confessions by our suspects and by their cohorts. Time and again, the best evidence in one of our cases has been the defendant's own signature on Nazi documents that somehow survived the war, later to be found in archives here and abroad by OSI's investigative historians. We are the only prosecutorial unit in the country that possesses its own complement of historians, and their great work has probably been the single most important factor in OSI's success. An instructive example of how OSI marshals documentary and other evidence is the office's lengthy report on the wartime activities of former United Nations Secretary General and later Austrian President Kurt Waldheim. On the basis of that report, Waldheim became, in 1987, the first sitting head of state ever to be formally barred from entering the United States. OSI's border control efforts have identified and added to the Interagency Border Control Watch List database the names of some 70,000 other World War II war crime suspects, including Japanese citizens who took part in the notorious medical atrocities perpetrated by Unit 731 of the Japanese Imperial Army, and others who participated in the so-called comfort women mass rapes perpetrated against women and young girls in Japanese-occupied areas of Korea, China, and other Asian countries. The text of OSI's report on Waldheim is posted on the Justice Department's website, where one can also read my office's report on the investigation that ascertained the fate of the infamous Auschwitz selector and experimenter Dr. Josef Mengele, and also our reports on post-war intelligence utilization of Klaus Barbie and other former Nazis. Contrary to popular belief and to the Hollywood conception of this work, our prosecutions have not originated with tips from self-styled Nazi hunters, or for that matter, from Holocaust survivors or other members of the public. In the early years of OSI's program, many OSI investigations were commenced on the basis of leads provided by foreign governments, especially the Soviet Union, that were searching for perpetrators. For nearly 20 years now, however, virtually all of OSI's prosecutions are traceable to my office's own proactive investigative efforts. Based on more than 2 decades of archival and other research by OSI personnel, we've collected the names of tens of thousands of individuals who served in mobile killing units, collaborationist police detachments, SS death camp and concentration camp guard details, and the like, or whose names appeared on post-war wanted lists, or who, for other reasons, may reasonably be suspected of complicity in Japanese or Nazi wartime crimes. OSI has managed to obtain birth date information on most of these individuals, and then we have methodically checked the names, thousands and thousands of names, against U.S. immigration records and other domestic records in order to identify suspects who have come to this country. When we find a match and the person is determined to still be alive, the investigation in chief begins. The goal, of course, is to determine what the suspect did during the war. In a conventional law enforcement scenario, one goes from the crime or the crime scene to the perpetrator. So, for instance, there's a dead body with multiple gunshot wounds at the intersection of Lee and Superior Roads in Cleveland Heights. And the task for the detectives is to deduce who the murderer is. In OSI's cases, in contrast, we typically go from the perpetrator to the crime or crimes. OSI, by the way, is highly unusual by law enforcement standards in that substantially all 3 main components of the work in these cases are performed in-house: investigation, prosecution, and appellate advocacy. Unlike other Justice Department components, we do our own investigative work rather than have agents of the FBI or other federal agencies perform that function. Our defendants have included senior-level officials of Axis regimes, such as Andrea Artukovic, the Minister of Justice and Minister of the Interior in the Nazi puppet state of Croatia. He signed decrees expropriating the property of all of Croatia's Jews, other decrees requiring Jews to wear distinctive markings on their outer clothing to identify them as Jews, and another decree setting up a nationwide system of concentration camps. One of the decrees he signed even commanded that when adults whose arrest for internment in the camps could not be found, but their children were left behind, the children should be sent to the camps. Artukovic was ultimately extradited to the former Yugoslavia. He was tried, convicted, and sentenced to death. He died in prison of natural causes before that punishment could be imposed. Another high-profile defendant was Arthur Rudolph, who was operations director of an underground V-2 missile fabrication factory that was part of the Dora-Nordhausen concentration camp in central Germany. Forced to work under grotesquely inhumane conditions, large numbers of Rudolph's inmate slave laborers perished. After the war, Rudolph was brought to the United States by the U.S. government in a then-secret program, and he was put to work on America's missile program and then on our nascent space program. Rudolph eventually was put in charge of constructing the Saturn V rocket. It is thus a sad part of our nation's history that the rocket that took humankind to the moon in 1969 was built by a Nazi slave master. On advice of counsel, when confronted with our evidence, Rudolph relinquished his U.S. citizenship rather than fight a denaturalization case in federal court, and he went back to Germany. Our defendants have also included what may be termed the trigger pullers of the Holocaust, such as former New York City area resident Jacob Reimer, who, when I questioned him at the U.S. Attorney's Office in Manhattan, reluctantly, very reluctantly, admitted participating in a mass shooting of Jews near Travnicki, Poland, intended, as he put it, quote, to exterminate a labor camp, close quote. And our defendants have included perpetrators whom our German colleagues call Schreibtischtäter, literally desk murderers, people who've issued the lethal orders from the safe remove of their offices. Alexandros Lulakis, whom OSI found in Norwood, Massachusetts, near Boston, was one such murderer. I well recall taking part in a stakeout outside his house early one chilly morning, followed by an interview in which he insisted to me that although, yes, he'd been chief of the Lithuanian security police in Nazi-occupied Vilnius, that's the Lithuanian analog to the Gestapo, he hadn't had anything to do, he said, with the Jews. It was the Germans, he protested, who'd handled all aspects of the so-called Jewish question, including the ghettoization of the Jews of Vilnius. More than 50,000 innocent civilians, men, women, children, babies, and their systematic removal to the killing pits at the wooded hamlet of Panarai, known in Yiddish as Ponar, in Polish as Ponari. Later, when we found documents bearing Lulakis' signature and consigning Jews, among them a 6-year-old girl named Fruma Kaplan, to the killing squad at Panarai, Lulakis' lawyers interposed the surprising defense that their client was merely, quote, a disembodied issuer of orders, close quote. Lulakis was surely turning the Nuremberg superior orders defense on its head, which really amounted to an admission of culpability. Even those of us who had worked on Nazi cases for many years, frankly, were shocked to see a death warrant for a 6-year-old girl. Little Fruma Kaplan had disappeared in the maelstrom of Nazi genocide more than half a century earlier, shot to death as she and her mother, Gita, shivered in fear, facing their executioners in the bitter cold of a late December day at the edge of a pit in the forests of Panarai that contained already the bodies of thousands of dead and dying people who had preceded them to the killing site. The terror of this mother and child is surely unimaginable. But for the remarkable detective work of OSI senior historian Michael McQueen, exactly what had happened to Fruma Kaplan and so many other victims of Alexandros Lulakis and his men would likely have remained unknown forever. Judge Stearns of the Federal District Court in Boston revoked Lulakis' ill-gotten U.S. citizenship on our motion for summary judgment. The judge found him complicit in some 50,000 murders of Jews, including those of Gita and Fruma Kaplan, mentioned by name in the opinion. I believe that Judge Stearns was as moved by their fate and as appalled by Lulakis' actions as we were. As Auschwitz survivor and Nobel laureate Elie Wiesel has observed in connection with the ongoing efforts to identify Iraqi victims in Saddam Hussein's mass graves, quote, the moment you give a face, a name, not just to the victim, but to the killer, people respond with greater comprehension. It somehow puts limits on the phenomenon, he writes, which otherwise is incomprehensible because of the numbers and the magnitude. Leleikis, by the way, soon gave up the fight and returned to Lithuania. There he became the first person to stand trial on genocide charges in post-communist Europe. These developments, all of them, the identification of Leleikis, the commencement of suit, the victory in the case, his departure for Lithuania, his prosecution for genocide, all of them, inexplicably, but typically for OSI cases, were reported neither by the self-proclaimed newspaper of record in my old hometown, nor by any of the U.S. broadcast networks. By the way, the fact that Leleikis had been employed after the war by the Central Intelligence Agency, which we could not disclose at the time, and which surely would have interested the media, certainly did not make things any easier for us as prosecutors. Some here will recall that OSI found one of Leleikis' men, Algimantas Dalida, here in this area in Brecksville, Ohio. Using captured Nazi documents, we proved that Dalida took part in arresting Jews in Vilnius, most notoriously in a sting operation in which his security police unit improved its arrest totals by using a Confederate to lure Jews to a phony escape route from the ghetto. Dalida's U.S. citizenship was revoked by order of Chief Judge Paul Mattia, who found that following their arrest, these terrorized Jews were sent to Panerai to be shot or were first sent back to the ghetto for confinement under inhumane conditions. We subsequently won a removal order against the Cleveland real estate agent, and he ended up in Germany. Just a few weeks ago, Lithuanian prosecutors announced that Dalida will be tried on genocide charges. Dalida, by the way, is one of 11 Nazi criminals found to date in Ohio. Only 3 states have provided more activity, shall we say, for my office. And in that group of 11, of course, there is one individual who is the subject of ongoing proceedings, namely John Demjanjuk, a case about which I really can't say anything because it's in litigation still. In addition to our law enforcement work in the Nazi cases, we've undertaken some major ancillary projects over the years, such as the previously mentioned Barbie probe. For a number of years during the 1990s, OSI performed the principal investigative work for the interagency federal effort to trace the fate of gold, artwork, and other valuables looted by the Nazis from their victims. That work not only resulted in tens of millions of dollars worth of gold being surrendered by governments and the proceeds of its sale applied for the benefit of needy Holocaust survivors around the world, it also led to the discovery of a looted painting in the collection of the National Gallery of Art in Washington, D.C., a few blocks from our office. That very valuable artwork was belatedly returned by the National Gallery to the Jewish family in France from which it had been looted many years earlier. For more than 7 years, OSI has represented the Attorney General in an interagency task force established to implement the provisions of the Nazi War Crimes Disclosure Act of 1998. That landmark statute requires the government to locate, declassify, and disclose substantially all classified records in federal possession relating to Nazi criminals and their crimes. This legislation was the product of a remarkable bipartisan project in the Congress. It was the brainchild of Representative Carolyn Maloney of New York City, whose vision was made a reality principally through the untiring efforts of Ohio Senator Mike DeWine. He told his then staff member Louis Dupart, a former Clevelander, to do whatever was necessary to get the legislation enacted, and Louis used his consummate skills to do just that. Since that time, the senator and the congresswoman have kept the heat on U.S. intelligence agencies to make sure that they comply with the disclosure requirements of the law, something that they have sometimes been less than eager to do. Not even the congressional sponsors, however, could have imagined that our implementation effort would turn into the largest search, declassify, and disclose program in world history, or that we would find and release more than 8 million documents and counting. In archives at the CIA, FBI, Department of Justice, Department of State, and elsewhere, we've unearthed documents that have made possible important revelations about the post-war fate of Nazi criminals, including the identification of perpetrators who gained employment with Western and Warsaw Pact intelligence services. We also found documents that yielded disturbing information about the war itself. For example, we found British intercepts of Nazi communications in which the SS was making plans for the autumn 1943 roundup of the Jews of Rome, the oldest continually extant Jewish community in the Western world. Jews in Rome had heard rumors that Germans were killing Jews, but hardly anyone believed there was any chance that Italian Jews could be targeted in this fashion. British intelligence knew many days in advance of the commencement of the roundups. However, His Majesty's government took no steps to tip off Jewish leadership in Rome through its intelligence agents. As a result, Rome's Jews were caught completely unawares, and many were seized and sent to be murdered at Auschwitz. In her excellent book on the history of the Holocaust in Italy, Susan Zuccotti writes of one Roman Jew named Settimio Callo. The commencement of the raids found him online to purchase cigarettes, which were being rationed. When the raids began, he raced home, hoping to save his family. But he arrived too late by just minutes. Beds in his apartment were still warm. Settimio Callo never again saw his wife or any of his 9 children. I must admit that I've been disappointed that despite the countless hours that my colleagues and I have spent questioning mass murderers and other participants in Nazi crimes, we seem to have learned so little about the mentality that enabled people to persecute and kill innocent civilians. Perhaps this isn't surprising, given that the standard position of our suspects and defendants is that they didn't commit any crimes. Indeed, concentration camp guards prosecuted by OSI have routinely claimed that they guarded only the perimeter of the camp and didn't even know what was going on the other side of the fence. They didn't smell anything unusual in the air, didn't hear any cries, didn't see any bodies. I myself questioned a longtime aide to Adolf Eichmann, who adamantly professed ignorance about the fate of the Jews, even when I confronted that individual with a document that this former SS functionary had signed for Eichmann, commanding that thousands of Jews be transported from Western Europe to Auschwitz. Many of us had hoped that our work would provide a window through which we might better understand how people were able to sign such orders. In the end, as I say, I don't think that's happened. Speaking for myself, I still can't really understand how it is possible to kill a child. How then does one explain the fact that that particular crime, the murder of a child, was repeated over and over, day after day, month after month, until fully 1 million Jewish and Gypsy children lay dead in the killing pits, crematoria, and camps of civilized, in quotes, Europe. Many of the killers were doubtless motivated by hatred, and the Nazis used their propaganda apparatus tirelessly to incite and deepen such dangerous sentiments against Jews and Roma and Sinti peoples. My office prosecuted 2 such hate propagandists. Other killers were perhaps not consumed with hatred, but they dutifully followed orders for fear of ostracism by their comrades or to avoid being sent to combat assignments where they would have to face other armed combatants, not just defenseless, unarmed civilian men, women, and children. Whatever the motivation, I must tell you that I am still waiting for the first defendant in one of our Nazi cases to express even a tiny bit of remorse for what he did. There is some encouraging news that I can provide regarding the fate of human rights violators in our country. I'm pleased to report, as Professor Sharp said, that the investigative and prosecutorial expertise that we've developed at OSI in the Nazi cases is now being applied in other cases of human rights violations. The Intelligence Reform Bill that the President signed into law a little over a year ago contained provisions initially introduced by another bipartisan team, Senators Leahy and Hatch, 5 years earlier, provisions that expand OSI's mandate to include citizenship revocation cases involving participants in genocide and in torture and murder perpetrated under foreign government sponsorship. There is no doubt that just as Nazi criminals managed to immigrate to this country in large numbers after World War II, perpetrators of more recent crimes against humanity have also fled to the United States and made new homes here. OSI has already assisted in a successful prosecution of one such perpetrator, the Cuban torturer Heribertos Medeiros, who was convicted of criminal naturalization fraud in an outstanding prosecution mounted by the U.S. Attorney's Office in Miami, Florida. As in the Nazi cases, denaturalization in the so-called modern cases will be a precursor to removal, which will be handled by the Department of Homeland Security. That agency has created special units to pursue the human rights violator cases, and my office works very closely with them. There may also be some cases in which criminal prosecution is possible, for example, for naturalization fraud, as in the Medeiros case, or under the torture and war crimes provisions of the Federal Criminal Code. The Department of Justice will prosecute those cases to the fullest extent of the law, to obtain punishment where possible, and ultimately to remove these individuals from this country. As in the Nazi cases, we seek to vindicate the concept that victims of these crimes who've made new homes in this country must not be forced to share their adopted homeland with their former tormentors. In this country, at long last, the victims should no longer have to live in fear of encountering those who mistreated them and their families so cruelly in other lands. At the same time that the U.S. government's efforts to pursue justice on behalf of victims of all crimes against humanity have expanded, we're witnessing the creation and enlargement of law enforcement programs in other countries similarly devoted to identifying and prosecuting perpetrators of modern-day human rights abuses. My office works very closely with our counterpart units in Canada, Germany, Denmark, Holland, the United Kingdom, and elsewhere, and with the UN-sponsored international criminal tribunals to investigate these cases, which involve crimes perpetrated in Rwanda, the former Yugoslavia, and in a frighteningly and depressingly long list of other countries. I should tell you that when it was announced in late 2004 that President Bush would sign the bill expanding our jurisdiction, an OSI attorney dispatched an intra-office email in which he suggested that we might start by investigating crimes committed in Rwanda and the former Yugoslavia. This immediately touched off a flurry of email activity within the office, as various staff members suggested additional countries in which crimes against humanity had occurred. Finally, one office wag dispatched an email in which he suggested that it might be easier, actually, and require a shorter list if we instead named only those countries in which no such crimes had taken place. However, while we can point to very real progress that has been made in pursuing the perpetrators of crimes against humanity continued in recent years, and I again salute the extraordinary work that Case Law School has done, faculty and students in that area, I would be remiss if I did not point out the regression that has occurred with regard to the perpetrators of World War II cases. Europe, in particular, has largely abdicated its moral and legal responsibilities in the Nazi cases. The overwhelming majority of the most heavily implicated surviving perpetrators of Nazi crimes are neither in North America nor, despite what novelists and Hollywood screenwriters seem to believe, in South America either. They remain where they have always lived, in Europe. Yet for many, many years, nearly all of the Nazi prosecutions have taken place in the United States and Canada. The opening of archives behind the Iron Curtain that attended the collapse of the Soviet Union and the dissolution of communist rule in Eastern and Central Europe in the last decade led to the discovery of a veritable treasure trove of evidence that made it possible for dozens of new prosecutions to be instituted in North America, indeed making it possible in 2002, despite the extraordinary lateness of the date, for OSI to set a new record for most prosecutions commenced in a single year, 10 new cases. However, that historic development has been all but ignored by European authorities, who have commenced hardly any prosecutions. For example, it has been more than 35 years since Austria last prosecuted a Nazi case. Perhaps worse still, non-cooperation by European governments has undermined the U.S. government's ongoing efforts to secure that measure of justice that I mentioned on behalf of the victims of Nazi crimes. Time and again, the governments of Europe, with the notable exception of Lithuania, have refused to readmit into their territories Nazi criminals against whom my office has won hard-fought court decisions revoking U.S. citizenship and mandating removal. The result is that the United States, whose families lost 200,000 of their precious sons and daughters in the desperate military campaign to bring an end to Nazi tyranny and mass murder, that country now finds itself effectively unable to remove some of these adjudicated Nazi criminals. Germany, whose prior government directed the perpetration of these crimes, whose government provided the perpetrators with the means to carry them out, and even paid them to do so, that same Germany consistently blocks us from returning Nazi criminals to Europe. 2 years ago, Romania even enacted a law specifically intended to block the U.S. government from returning Romanian-born Nazi criminals to their country of origin, yielding some pointed criticism in the most recent State Department country report on human rights for Romania, and also in the Religious Freedom Report. In a job that, as you might imagine, has always been suffused with frustration, our inability to carry out these deportations is perhaps the biggest frustration of all. Worse than frustration, however, has been the tragedy of the murder of my then deputy, Mike Bernstein, by terrorists while he was returning from a trip to Austria that should never have been necessary in the first place, but that was made necessary by the Austrian government's refusal to discharge its legal obligation to accept the return of Nazi criminals who immigrated here from Austria. Mike was murdered along with 269 other innocent people above Lockerbie, Scotland, and on the ground there when Pan American World Airways Flight 103 was blown up by Libyan agents in December of 1988. We can only hope that in the so-called modern war criminal cases, we will encounter more enlightened and cooperative conduct on the part of foreign governments. However, having experienced the frustration of seeing Japanese and Austrian governments, or the Japanese and Austrian governments, refuse even to assist us in our World War II investigations, a refusal that persists to this day in Tokyo, the best I can do this afternoon regarding the modern cases is to express cautious optimism. I can, however, pledge to you that my colleagues and I at the Department of Justice, including my wonderful colleagues here from the U.S. Attorney's Office, will attempt to continue to leave no stone unturned in the quest for justice on behalf of the victims of crimes against humanity. Doing so, we believe, is an essential component of fidelity to the long-delayed legacy of Nuremberg. Doing so is also, quite obviously, a moral and a practical imperative. We must, at long last, create a world in which anyone who would dare even to consider perpetrating crimes against humanity will know to a certainty that if he or anyone else who's affiliated with him acts on such pernicious thoughts, they will be pursued, as the Allies warned the Nazi murderers on November 1, 1943, quote, to the uttermost ends of the earth, to be delivered to their accusers in order that justice may be done. Thank you very much. Apparently, thank you so much. Apparently, I've not used up all the time, so there is some time for questions.
There's 13 or 14 minutes for questions. When you raise your hand, wait for a microphone to come to you. Speak into the microphone. There are people watching this upstairs, and also this is being webcast. Okay? And you can just identify who you want.
Start up front.
Mr. Rosenbaum, thanks so much for coming. First of all, I'd like to congratulate you on all the work that your office has done and has achieved. One question that has come to my mind throughout your speech, we know today that women are affected differently by war crimes. They tend to be victims more often, and the nature of their crimes are different. Can you discuss how your office deals with women and if they're dealt with as a special class?
They were dealt with as a special class in the Japanese cases so far, where we were able to identify a comparatively small number of people who were implicated, as I said, in the so-called comfort women crimes. I really dislike that term, but that's what the victims groups use. It's unfortunately the Japanese term. And they weren't just women, they were little girls, too. We fought real hard to identify those perpetrators, put them on the watch list so they couldn't come to the United States, and to persuade the government to let us announce that that was what we had done. Frankly, a lot of us at OSI hoped that by making that announcement, we would help the groups that are seeking to have the full truth of what was done disclosed, and for there to be not only historical justice but also compensatory justice. It was a little bit of a challenge because our draft press release referred to the crimes as mass rapes, which is a term one hardly ever sees used by the victims groups. It's a very sensitive term, but we thought that's what Americans would understand. And it caused a certain amount of alarm among American diplomats who worried that the Japanese government would, as I was told, go ballistic about that. And if I may tell one tale out of school, since it's only people here and millions of people watching on the internet, when we were discussing this, and I experienced the resistance at the State Department to issue the release, let us issue the release with the R word in it, I finally was reduced to saying, well, why don't you send it up the flagpole at your agency, and I'll send it up the flagpole at my agency, and we'll see how Secretary of State Madeleine Albright and Attorney General Janet Reno feel about our calling these crimes rape. That actually yielded an immediate offer of compromise, and so I think we used the R word 2 times instead of 4. I will add to that we were honored to have, as a visitor to our office, a Korean woman who had been one of the victims. And of all of the encounters that I've had with victims of war crimes and crimes against humanity, that's the one that was the most painful and the saddest. This woman was taken off the streets when she was still a girl. As she explained it to us, when they took me, I didn't even know what sex was. And then she was raped multiple times a day for many, many months. Finally, as the war ended, she escaped, managed to get a ride on a fishing boat back to Korea, where the sailors raped her en route. She got back to her village. The initial reaction of her parents was of delight that their daughter had somehow survived. They had given up hope. And then when they found out what happened to her, they sent her to Seoul because it was a humiliation to have been the victim of rape. In fact, she said to us, you know, I can't say in Korea what I am saying to you here because of the stigma that still attaches to it. And I will tell you that there was not Michelle, I don't remember if you were there for that, but there wasn't a dry eye in the room. So that's a long-winded answer to saying we are very much interested in those crimes, and they are treated as a special class of case.
I understand, we all know that Germans are notorious record keepers, and I understand that there is some kind of depository somewhere in Germany that powers agreed after World War II would store all the records that were gathered together, and there are records of virtually every victim of the Holocaust that are there, and but they're not live, they're not available, and there's a controversy going on now. Could you tell us a little bit about all that?
That was a story that appeared in the New York Times the day before yesterday, and it has to do with an archive maintained at Allied request initially by the International Committee of the Red Cross in Arleston, Germany, and it contains many thousands of records on individuals who survived the war mostly, and who thereafter sought family reunification or immigration out of Europe for obvious reasons. I am not privy to the details of this controversy. No one asked my view. I think it'll be resolved without my input as well. There obviously are privacy issues that will have to be addressed if those files are made public, since they contain personal data, medical information on people, thousands of whom are still living, not to mention information that in this era of identity theft would be of some value to bad guys. This was mostly information that was provided in confidence to post-war authorities to aid in the reunification of families and in immigration. So there will be some very sticky privacy issues that will have to be resolved. Why don't we go back there? On the right.
Thank you. Two, I guess, just legal clarification questions. The first is, what gives your office the standing and jurisdiction to do these cases? You mentioned a couple legislative acts, and following from that, what substantive law is used when prosecuting these cases? Is it ex post, or is it at that time? And is it specified in the acts?
We're talking about if I talk first about the World War II cases, we apply the Immigration Act provisions, Title VIII of the U.S. Code. At the time that these people gained entry, for the most part, there were laws on the books that forbade the entrance of people who took part in Nazi crimes of persecution. There also have always been laws prescribing the entrance of people who lie to gain their U.S. visas. At the same time, before these people were naturalized as U.S. citizens, there were in Title VIII, and remain in Title VIII, provisions that preclude the granting of naturalization, U.S. citizenship, to individuals who have not entered the United States lawfully, as in by lying to get in, or as being barred as Nazi criminals, or the provision or granting naturalization to individuals who lie to obtain naturalization. And those are the principal provisions that we apply in the World War II cases and that we expect to apply in the so-called modern cases. In the modern cases, there are, as well in Title XVIII, provisions covering genocide, torture, and war crimes. And where appropriate, the Justice Department will prosecute people under those criminal statutes. Okay.
You alluded to Operation Paperclip, in which the U.S. government covertly brought Nazi scientists who had what were then perceived as very valuable technical skills, particularly in aeronautics, to the U.S. When your offices come up against walls erected by the CIA or the Defense Department and whatnot, what have you generally found to be the best techniques to break down those walls, even before the law was enacted as to declassification?
Well, I must say, we in our work have not encountered those problems. We've gotten really, we believe, very good cooperation from CIA, from FBI, from the State Department. There are certainly issues of public access to their information, but on an interagency basis, we have gained access to the information that we've needed. I think you're supposed to wait for the mic up here.
I find it somewhat dumbfounding that you can find a person who's gained illegal entry here, and then, because their home country unilaterally decides they're not going to accept them, what's their disposition at that point?
Well, it is enormously frustrating, and I've been dumbfounded myself. We continue to press governments in Europe to take these people. I'm cautiously semi-optimistic there. I should tell you that when we win a final order of deportation in these cases, the Social Security benefits of these individuals get canceled immediately. In a few instances, we've been able to take people into custody. And one of our defendants is currently in custody in Michigan and has been in jail, I think, for about 2 years. He went underground to avoid service of the charging documents in our deportation case, and we finally found him hiding in a house in a basement under a stairwell in a specially built secret compartment. And when we went to court and he tried to get out on bail, he denied that this was a compartment for hiding. And we then put on the stand the Homeland Security agent who found him in there, and the question was did the door behind which this individual was hiding, did it have a lock? Yes, sir. And where was that lock? On the inside. So it's a new kind of storage compartment with the lock on the inside. But I deeply frustrated by that problem.
One last question.
Okay. If there's no question, I'll tell my one story then. I have an Ohio story. I was hoping that the question would elicit this story. Tell it, the fast version. Involves a well-known former Ohio figure by the name of James Trafficant, who wanted to join us today, but he's unavoidably detained. Many years ago, after we removed Arthur Rudolph, this rocket scientist I mentioned before, to Germany, an effort was launched by some of Rudolph's friends to somehow get this all undone and bring him back to the United States. He had been wronged by the United States government, they said. And we learned through an informant that they had a plan. He was going to fly into Canada. He couldn't get into the United States because he was on the watch list. He would fly to Canada. He would be met by his supporters there. They would convene at Niagara Falls, Canada, there to be joined by then Congressman Jim Trafficant. The plan they hatched was that they would march over the Freedom Bridge into the Empire State with Rudolph handcuffed to the congressman. And the plan was, if the U.S. Immigration Service personnel on the bridge stopped them, the congressman was to say, I am en route to Washington to vote in Congress, and you may not interfere with my travel. Well, I panicked. I think I was pretty new in the job as director, and I called INS, and they patched me through to the Freedom Bridge. And I was speaking with an inspector there, and I breathlessly told him this story. And he said, don't worry, we'll handle it. And I said, really? And he said, yeah. And I said, well, I hope you wouldn't mind if I'm just curious, how do you propose to handle this? He said, well, if the congressman comes over the bridge with Arthur Rudolph handcuffed to one wrist, we will handcuff Rudolph's other wrist to the bridge. And we will tell the congressman that he is welcome to stay handcuffed to Arthur Rudolph for as long as he wishes. Anyway, you have been very patient with me for a long time, and I thank you again so much. Thank you again. That's lovely.
And please join us upstairs for a reception, and Eli will answer more of your questions on a one-on-one basis.
Thank you, Michael. I went on a little long, but...